Your Worship, my learned friend Mr. Forbes appears for 4N5. That's Mr. Sharma in Mulane. Forbes, yeah.
And then 1 and 2.
You want to just place yourself on record here?
As it is with the court, Your Worship, I am Ms. Kuti from Shangana Attorneys. I'm appearing on behalf of case number 1.
As the court, Your Worship, I'm Ms. Wilan from Morocco Attorneys. I'm appearing for accused number 2. As it is the court, Your Worship, it's Ms. Matsosa from Morocco Attorneys. Appearance on behalf of accused number 3.
Worship, as the court pleases, Mr. Forbes from Forbes Attorneys in Pretoria, I confirm my appearance on behalf of accused number 4 and number 5. Number 5 being represented by accused number 4.
As it pleases the court, Your Worship, Lee Beneman and Schindler's attorneys, appear for accused number 6 and number 7.
Number 6?
That's correct, Your Worship.
He's not here present. No, later. I must point out to Your Worship, accused number 6 is. I understand my learned friend wants to give the court the reason for that.
Yes, Your Worship. I just wanted to afford my colleague an opportunity to complete his calling of the roll. I bring to your attention that my client, accused number 6 and number 9, is not available today due to medical reasons. I've been provided with a doctor's certificate, which has also been emailed to the state this morning, so we're in possession of it. And if you would like me to do so, I will read it into the record. Alternatively, I'm going to then say not for your consideration.
My learned friend has seen it. I haven't seen it. It may have been emailed to us, but I'll be remiss in my obligations not to inform the court, and I don't want to take my learned friend by surprise. But a medical certificate doesn't constitute evidence. It's hearsay, and of course, it's ultimately the court will decide whether you accept it or not. But it's not. The authorities are very clear in our law. It constitutes hearsay as evidence. And if there is a serious attempt, it should at least be by way of affidavit. But I'll leave that in your lordship's hands. But just to formally put on record that the state's attitude, certainly in future, will be that if one is relying on medical certificates, it doesn't meet the criteria of Section 3(1)(c) of the Evidence Act, the Law of Amendments of Evidence Act from recollection 1988. There's a Labor Appeal Court judgment which extensively deals with the probability of medical evidence, and on all authorities, a medical certificate per se does not even meet the criteria of any probable value, because it's sheer hearsay. In the least one would expect affidavits. I simply want to put that on record.
Now, what is the request of the state?
I'm sorry?
What is the request of the state?
The request of the state is I leave it in the discretion of the court. I haven't heard what the reasons are, but I'm simply putting it on record what the procedure will be in future in this particular matter. It's going to be a long drawn-out matter. That will be the future position of the state. I don't want to take my learned friend by surprise and say to him, well, I want affidavits to be produced this morning. But of course, I can't override what your worship wants to do. with the content of the affidavits, or in fact the court itself, because we go to the integrity of the court and rule of law, then there'll be an inquiry. But the practice of simply producing a medical certificate, I point out and I put on record, in itself constitutes no evidence. So that document that your lordship is, your worship is relying on, it's not only hearsay, but in fact, the content itself is meaningless because it's not based on the oath. I simply point out that's the correct position. The position where my learned friend says you produce a medical certificate and you're not happy, then you have an inquiry. That's not the correct position. The correct position, you put the best evidence available, which would be in the form of affidavit. If that's not sufficient, then you have an inquiry. Simply want to put the correct position. And the leading case, I have it in my diary. It's Mogobesi, this is Nigel N.O. and others. I'll invite my learned friend to look at it. 2006, 27, ILJ, 786 is a judgment of the Labour Appeal Court, but comprehensively analyzes the veracity of medical certificates when you're using that as an excuse, because it's fundamental. It's not what is convenient to the parties, it's what the respect and rule of law principle dictates for the future administration of the court.
Yes, Your Worship.
Then in this, there is no indication until when no clarity is given.
Yes, Your Worship. Your Worship, unfortunately, I'm in the hands of the letter. I can only attest to what is contained therein. To the extent that I must give an undertaking that my client will be present on the next occasion. I'm in the court's hands. The only request that I can make, Your Worship, is that you consider the documentation before you. The practice, as I understand it, in the course and scope of these procedures, is to demonstrate the best of the evidence available, which at this stage is that letter, make it available to court, be in the court's hands. To the extent that a warrant is then issued, I humbly request that it be held over until the next occasion.
That will continue.
So just for the next occasion.
How do you know that on the next occasion it is accused?
I beg your pardon, Your Worship.
How do you know that it is accused for that day? You speak of the record. There's no indication who was accused.
Your Worship, I can't take that matter any further other than to say that I would expect that to the extent that there was going to be a protracted period of time that the accused of my client would not be in a position to attend this trial, having consideration to the dates that had been postponed in the past, that it would have been an indication that he would not be available on the next occasion. I am not ready to believe anything to suggest that he won't be available on the next occasion. As I understand, the date has been arranged in the future to the December date, and there's nothing to indicate at this stage that he won't be available.
Now, by agreement, your worship can record it's a final is on the 6th of December 2021. We will be in a position then to approach the High Court for the matter to be transferred to the High Court. And as I understand the procedure in the High Court is we will have to confer with our learned friends and they're available for 3 hour conference before the Judge President or the Judge allocated by him to deal with the matter. Your worship can also report that the final indictment will be served on our learned friend by no later than the 29th of October 2021. Mr. Binneman, wanted to raise the issue that there must be finality to the matter. I understand that once we were prepared to give him an undertaking that this would be a final postponement, then he won't have a problem.
The date of the 6th of December, it's a personal matter of the High Court, not the date for High Court.
No, coming back to this court,
Coming here.
back to this court. And by that date, we would make arrangements for the matter to be transferred to the High Court.
I didn't hear you clearly now. The reason for postponing until the 6th of December is for what?
Is for purposes of serving the final indictment on the legal representatives of the accused, which we have undertaken to do by no later than 29th October.
Now, I just want to correct for 5 and 6. All 6 of them were already out on the
All 6 of them?
Yeah,
Yes,
out
yes,
on the-
yes, Your Worship.
Council, we confirm the submission made by the state, at least 1 to 6.
I confirm the date, Your Worship.
Motion to confirm that the date is suitable.
As it pleases the court, Your Worship, date is suitable with me also.
Your Worship, confirm the date is suitable. Defense would also just like to place on record and get the state's undertaking that any additional disclosure in this matter also be furnished on or before the 29th of October 2021.
State, as just for this podcast speaking, there's no indication when this case number 6 will be fit to approve. What is your opinion? What is your
I understand from my learned friend, he believes that his accused will be available on the 6th of December.
Do you have any objection if the warrant is issued and you write over until the 6th of December?
No, Your Worship, no. Can I do it immediately after this? Okay.
I hardly asked permission to approach my client. I hardly asked permission to approach my client for one. Is that what you said?
Yes, if they're going to add accused number 7 in due course. Yes.
Yes.
Accused number 1, 2, 3, 4. Methods postponed until the 6th of December 2021 for serving family custody to the defense. You are out on bail. The bail is extended. You are warned of custody to appear in this court remain in attendance. Accused number 6 is absent. A warrant of arrest is authorized for the read over until the 6th of December 2021. Accused number 6, bail is provisionally cancelled. Bail money is provisionally forfeited to the state. Then the methods postponed until the 6th of December 2021. Accused number 1, 2, 3, 4.
As a court, please, Mr. Bishop.
May I have the excuse?
Yes, very well.
Thank you.
Tolo hasn't signed his bail statement. I said, Tolo hasn't signed his bail statement. It is going to be a problem. Okay, fine. We'll do it. Thank you. Thanks. I got it. This was given affidavit in support.
We can't just say that we're not proposing that we have to do it. One is original and the other this is for the court, no? The original one and the other stuff open for one for them, one for you to read.
Thank you very much. Just keep up to the statement.
You may proceed.
Thank you, Your Worship. Your Worship, my learned friend, Mr. Joubert, appears for accused number 7, Island Investment 180 Pty Limited, and he also appears for Ms. Raghavan, who is added on as accused number 8. Your Worship, before my learned friend as an opportunity of addressing your Worship, previously there was a warrant issued for Ms. Raghavan. The state will ask you to cancel that warrant. Then we have 2 affidavits, one by the investigating officer, Lieutenant Moloto, and one by the Ms. Raghavan in relation to bail. In short, bail is not opposed. We've agreed an amount of 10,000 rands for bail. If I may hand up the respective affidavits. We have furnished our learned friend with a copy of the affidavit of Lieutenant Colonel Motolo. Thank you, Your Worship.
What is the name of the accused number 7?
Accused number 7 is Islandside Investment 180 Pty Limited, as represented by Ronika Raghavan, who is now added on as accused number 8.
The lady's property.
Yes, she is.
Stand up. Now, it is her first appearance.
It is her first appearance.
When she was arrested in warrant.
Yes. She in fact, we asked our learned friends to make arrangements to bring her to court, and I understand they brought her this morning. Perhaps my learned friend can just enlighten us on that.
What happened, my Lord, Your Worship, is on the previous occasion, Islandside was required to have a director in court to represent the company. and Ms. Ragaban was nominated to be the director to represent the company. But she was unmedically unfit because she has various medical conditions. And they, for that purposes, it was arranged that the warrant will be, because she was served with a summons, a J175 summons to appear on the previous occasion, which was the 17th of September. So she was therefore required to come to the court to appear in her capacity as a representative of the company in terms of Section 332 of the Criminal Procedure Act. But she was medically unable to do so. So the attorney was here, together with counsel. Arrangement was made that because there was a J175 summons served on her, that she be excused and appear today. But yesterday the state decided that she's not only appearing in her capacity as a representative of the company anymore, she's also an accused now. And she has been added as an accused. And therefore she's now accused number 8, but she's also representing the company in terms of Section 3325 of the Criminal Procedure Act.
I'm indebted to my learned friend to clarify the position.
The original signed affidavit of Ms. Ragged one is actually here. The one you have there is an unsigned one. So I apologize. This is the copy from state.
What schedule is this?
The Schedule 5.
Schedule 5, please.
There are 4 charges in the charge sheet, but only charges 2 to 4 is applicable to Ms. Ragaman, who's the accused number 8.
I suppose we could hardly charge her under the PFMA Act. So, yeah.
Thank you. Your Worship, is we have prepared the affidavit, which we beg leave to hand. As Mr. Kassim and Friendship, the state, the IO made the affidavit, there's no opposition to the bail. He says, he confirms that she's not a flight risk. There's no likelihood that she can tamper with evidence or threaten witnesses. She has no previous convictions or pending cases. This was confirmed. Because he already served the summons on her on the 7th of September at that address, investigating the investigations are completed, and he is of the view, subject to the court's discretion, that she will not jeopardize the administration of justice or the bail system. In support of the application, Your Worship, we have compiled the affidavit, so I can either read it into the record, if Your Worship wishes to do, or I can just summarize it. Because there is no opposition, she has no previous convictions, she has a child who is 7 years old. It is plain and undisputed, and that none of the relevant sections of the Criminal Procedure Act and under Section 64A to E will be jeopardized. She came to be arrested this morning. Yesterday we received a call that she was handed herself over. We've said that out in paragraph 3.1. She presented herself this morning at 8 o'clock at the Bainsfleet police station. She was processed and she was brought to court. She has been living in Gauteng since 2003, and really the upshot of her position is summarized on page 8 of the affidavit, paragraph 4.2.6. She says the following: I respectfully submit that there is no justification to detain me any longer as she was arrested this morning, and submit that I will be severely prejudiced in the event of being further detained, and that the conditions in the prisons are appalling. I also urge this Honourable Court to consider the period that I might be detained until the matter is finalised, and the fact that criminal trials can take a considerable time before they are finalised. In view of the current pandemic and the fact that the Republic of South Africa is experiencing a new wave of COVID, I submit that my continued incarceration might be severely prejudicial to my health. Apart from the fact that the period of detention cannot be estimated with any form of precision, at the moment I request the Honourable Court to take into account that I will not earn any income whilst so detained. I therefore stand to suffer considerable financial hardship and loss. I also urge this Honourable Court that should I be detained and refuse bail, I would be prejudiced in the preparation of my defence. It's extremely difficult to consult with legal representatives inside prison, and I have no doubt that my continued detention will seriously jeopardize my preparation for trial. I have various and chronic health issues and do not enjoy good health. I'm a diabetic type 2, I suffer from hypertension and antiphospholipid syndrome, it's a blood disease. I have a lung embolism. I also suffer from serious skin eczema. I am on various chronic medication and immunosuppressants, which causes me to be bedridden for long periods of time. I also frequently get kidney infections. I've already been arrested on the 14th of February 2018 in this matter, and as well, and the court released me on bail on the 15th of February 2018. I faithfully complied with all my bail conditions until the charges were withdrawn against me on 4 December 2018. As recently as 7 September 2021, Colonel Mtolo, the investigating officer in this matter, came to my residence to serve the summons to represent the company Islandside Investment 180 in this matter on me. You can therefore verify my residential address. As can be seen from the history of this matter, as set out herein, I have been aware of the alleged charges since February 2018, and I did not abscond. As stated, I am innocent of any alleged allegations leveled against me, and I do not fear conviction as I did not do anything wrong, nor did I have any knowledge of wrongfulness to commit any crime. I respectfully submit that I am not a flight risk and that I will stand my trial. My personal and medical circumstances are set out herein, and the interest of justice do permit my release on bail, and that I am therefore entitled to be released on bail. The prosecution and the investigating officer also have no objection to my release on bail in the amount of 10,000 rand. I also understand that they do not demand any other further conditions for me to be released on bail. In the premises and taking into consideration the relevant schedule, the charges result under, I respectfully submit that the court ought to grant me bail in the appropriate amount and with such conditions attached as the court may deem just. Your Worship, So therefore it is submitted that insofar it is necessary for the accused to discharge the owners, that it is in the interest of justice for the release of bail. She has done so. The state and the investigation officer do not object, and if your worship is satisfied with the amount posed, as your worship can see, she was already through this exercise 2 years, 3 years ago, when she was initially arrested on the same charges, and they were withdrawn. So if your worship is satisfied, we would ask that the court can release the accused on 10,000 rand bail, and the only condition is that she should appear on the 6th of December, which is the arranged date for the next appearance. Unless the court wants to hear me on any specific aspect, your worship then would conclude the application and the submissions on behalf of for bail on behalf of you. Thank you.
Your worship, may I just make two observations. The one is I'm instructed, your worship, to ask the accused to surrender a passport, if that's in order. Mr. Yobel.
Yes, we have the passport here.
And the other one, your worship, I must just point this out to your worship. If your worship, paragraph 1.4.4 of her affidavit, she says to your worship, in 2001, 1.4.4, she says, in 2001, I commenced my employment at Correction Computer CC, which later became known as the Sahara Computer Group. The entity's exact name changed throughout the years. I have only ever mainly been employed by Sahara Group, although I held directorships in other companies that formed part of the group. I was also director of Arrowhaven Trading. I'm also director of Ironside Investments 180 and various other companies in the Oak Bay group of companies. Currently, I'm the acting chief executive officer of Oak Bay Investments Pty Limited. Now, your worship, the famous case which has been reported relating to the banks and the fight with Oak Base, I just want to point out to you that the Oak Base case is the well-known Gupta people. They own the companies. And literally speaking, billions of rands went through those accounts. And yet when you look at 1.5.7, where she documents her assets, she says, I own a 50% share of a property situated in Centurion to the approximate total value of 600,000. The property is situated at 1298 Bishopbird. I also own a Ford Fiesta, which is still subject to financing. It has a value of 100,000 rands. I have other movable assets of a personal nature valued at approximately 150,000. So my learned friend might think, why am I referring to these matters? But I think it's in the public interest simply to point those matters out to your worship. Here's somebody who's a director, chief executive officer, she tells your worship, of Island Concept, involving billions of rands. Of course, the state's case is those monies have been unlawfully dealt with. And then, of course, she sets out the assets in 157. I just point that out to your worship. I'm sorry to do this to your worship, but there's a further request from the state that, and my learned friend can deal with it, that she must, one of the conditions of her bail is that she can't leave the Gauteng province without conferring and obtaining the permission of Lieutenant Colonel Motolo. It's Lieutenant Colonel Motolo, M-T-O-L-O. There's a copy.
This number, I think, is that the ID number 2, 3, and 4? Huh?
2, 3, and 4. 2, 3, and 4. So it's the count of fraud, money laundering, and fraud.
It's set out in paragraph 14 of Colonel Motolo's affidavit. She's not charged in respect of count 1, which is really contravention of Section 86 of PFMA Act. She's charged with count 2, fraud, 3, money laundering, 4, fraud again. 14. 1/4 of the Colonel's affidavit. His affidavit in support for bail application. Under item D, I have it as page 10, Your Worship.
Bishop has the wrong affidavit.
What's the
The affidavit was, that is the iron. There's the second affidavit by the iron.
Sorry, Your Worship, this is the correct one. I'm sorry. My apologies, Your Worship. May I just hand up to Your Worship, please? Thank you. Sorry, Your Worship. I'm told Your Worship now has a copy in the original, so I don't have one, Your Worship. But it's page 10 at the bottom, under item D, paragraph 14. No, count 1 she's not charged. Count 1 is based on Section 86 of Public Finance Management Act. That's accused numbers 1, 2, 3 who were at the material time in the employment of the state. So she's charged with charge 2 or 3 and 4.
This application is unique, rather. As if we will not be assisted with the legal facilities. Now, this evidently is a book of the applicant for the new activity.
Exhibit?
I'm asking this purpose.
What exhibit will it be? Your Worship, yeah. Your Worship, for convenience, can we call it Exhibit X1, and then the Colonel's affidavit Exhibit X2.
X1.
X1, Your Worship. X2.
The
beg your wish.
Application.
Yes, just on the reply to my learned friend, the accused or the applicant was a mere employee in the OPay company. So whatever the OPay matters did is totally irrelevant in this matter, first of all. But secondly, Your Worship, the state can also verify the South African Revenue Services SARS has done a 10-year lifestyle audit on the accused as recent, and that was finished as recently as a month ago. And they found all her affairs to be in order. She was fully tax compliant, and there was no readjustment. So her entire asset situation has been verified by a strict audit of SARS, and they didn't find anything untoward to any extent. And she was a mere employee, so whatever the company's done was none of her business, and she cannot really be attributed to her with respect. But that is in any event, I would submit, totally irrelevant to this charges and the bail application before you wish. Worship, we have a passport. Captain Mtolo you can hand it over to him. He is present in court. And Colonel Mtolo is present, so I can surrender it now.
Thank you. I will pass it on to the Colonel.
There he is. And the condition that whenever she would leave Gauteng, either for business or for family visits, because the family resides in Durban, the arrangement will be that she will notify Captain Mtolo and get his permission, because in the past, in the year 2018, there was no issues with that. He was simply satisfied if she would notify him, and he would note it on his system or on his diary. So that's not a problem with respect.
Your Worship, I must point out that I read out 1.4.4 to the court because I have in front of me an affidavit by Ms. Raghavan, and in the affidavit she states under oath, I was also a director for Arrow Haven Trading. I was also a director of Island Investments, 180 Pty Limited, and various other companies in the Oak Bay group of companies. Currently, I am the acting CEO of Oak Bay Investments Pty Limited, and of course, director has a special meaning in the Companies Act, and I was inclined and obviously tempted to of the observations I made insofar as we went through companies in public records, in court reported, in reported cases, and of course I'm not in a position to dispute her asset base that she said. Evidence that, but I said the bizarre situation that one has when one reads 144, what's in the public domain, and 157. That's the reason I read it, as the court pleases.
State what's the case of the defense, anything from the state, anything to address from the state, anything, any address?
No, you know, Your Worship. No.
This is a formal bail application schedule 5 conference, unopposed bail application. The applicant in this matter is represented by Advocate
DJ there is
together. The state is represented by Advocate
Cassim, C-A-S-S-I-M.
The applicant in this matter is facing records, it's fraud, money laundering, which is count number 2, number 3, and number 4. claimants can be the five offense. It's required from the applicant to adduce evidence that satisfies the court that the interest of justice permits hearings and data. Affidavit of the applicant was read into the record. The applicant confirmed the content thereof, and the affidavit was handed in as in X1. That is the affidavit of the applicant. This one is not going to repeat the content of this affidavit. The affidavit was just read into the court. The amount of 10,000.